to hear from the appellant.
Good morning, Your Honor, or afternoon, Your Honor. My name's Radford Dimmick. I represent the appellant. I'd like to reserve 3 minutes for rebuttal.
That'll be fine.
Thank you, Your Honor. The issue before the court today is my client is asking for a reversal of a dismissal of a complaint for a will contest over in Johnson County. The dismissal was made as a result of a motion to dismiss pursuant to Rule 12.026. The standard by which a motion is of such a nature as to be looked at by courts is a presumption that all the factual allegations are true and to give benefit of all reasonable inferences to the plaintiff. And it is to only be granted, as Your Honors are aware, only when a plaintiff can prove no set of facts in support of their claim that would entitle them to relief. I would submit to Your Honor that my clients met this standard by pleading a specific paragraph in the amended complaint. And there are essentially 4 allegations that sustain a complaint for a lack of testamentary capacity and 4 specific allegations that to sustain a claim for undue influence. In the paragraph 3 of my client's amended complaint, it states that the plaintiff alleges that the decedent was incompetent and or disabled at the time of the execution of the will due to her physical infirmities or mental illnesses. There's a claim of incompetency, there's a claim of disability, there's a claim of physical infirmities, and there's a claim of mental illnesses. All 4, any one of those, if they are to be sustained by a preponderance of the evidence, would sustain a will contest in the state of Tennessee. Another cause of action that was claimed in the underlying amended complaint was that of undue influence. There is an allegation that the decedent's 2018 will was a result of undue influence upon the decedent by the defendants by reason of dominion, control, which was exercised by the defendant Temple Reese upon the decedent in an effort to persuade and influence the decedent to name Temple Reese as a primary beneficiary of a 2018 will. There's an allegation of dominion, there's an allegation of control, which was exercised by Temple Reese upon the decedent who executed the will, and it was done in an effort to persuade and influence her to name her as a primary beneficiary of the will. With that, Rule 801 is sustained. It's a short, all that Rule 801 calls for is a short, plain statement of a claim showing that the plaintiff is entitled to relief, and there is supposed to be a demand for judgment. All of that was done in the amended complaint.
Counsel, opposing counsel acknowledges, of course, what you pled in your complaint, but says that those are basically sort of legal conclusions, that there are no underlying facts. What's your response to that?
Well, to be candid, we don't have all of the facts, but we do have facts that we have pled which are enough to sustain our burden right now in a pleading. In their brief, as a matter of fact, the appellee cites rules of pleading, stating that it is my client's burden of proof, which is to be sure that's the case. But the complaint was dismissed under a Rule 12.06, 12.02, Section 6, which presumes that the facts are true, and the rules of pleading are to be liberally given liberal inferences to the pleader. So as far as the underlying facts, we don't have all of the facts, quite frankly, but we have pled sufficient facts. And if any of these facts that, as are alleged, are sustained, that is a prima facie case for the sustaining of a will contest under the laws of the state of Tennessee. We can't show every instance of undue influence. We'll probably discover a little more if we ever get to the realm of discovery, if we're allowed to get there, as to why she was of unsound mind. We haven't been afforded that opportunity, but the allegations...
Well, how do you know it's there to plead it if you don't have any, if you don't know the facts?
Well, we have enough facts to plead what we have pled. We know for a fact that Temple Reese exercised dominion and control to an extent that she influenced this decedent, this now decedent, to name her as the primary beneficiary of a will. We know that this woman was of advanced age and had physical infirmities, and everything we alleged here. That's what we know. If we were to go and make up or, guess at a bunch of facts, it runs afoul of Rule 11. So we have a burden of proof at trial, and the burden that has been sought to be applied here, both at the trial court and in this case with Apley's brief, is a burden of proof, and that's not the proper burden. We have a burden of pleading, and we've sustained that burden of pleading in the amended complaint by setting forth facts that would sustain a will contest. In the Apley's brief, they cite, they employ Rule 9.01 of the Rules of Civil Procedure. That's a misapplication of the rule. That's a rule that seeks to enforce capacity to be sued or not sued. That's inapplicable to testamentary capacity. Again, the Rule 12.026 motion tests pleadings, not proof. And everything that was pled has to be accepted as true. If any one of those four elements that I cited for any of those, for either undue influence or lack of testamentary capacity are to be sustained, if any of those are sustained as a matter of factually, then the will as a matter of law has to be set aside. Accordingly, a claim has been stated under the law of the state of Tennessee. Now, we may go to court and the appellee just kicks our tails and disproves everything that we have alleged. That's not what we're here for. This is a contest of pleading. The pleadings would sustain a will contest in the state of Tennessee, and we would ask that the ruling of the trial court be reversed and this matter be remanded for a trial.
Thank you. You have your time for rebuttal. Hear from the appellee.
May it please the court. Good afternoon. I am Mike Latier, and I represent the appellee Temple Reese. This case involves a will contest, and our position is that the trial court correctly found that there were not sufficient allegations in this case to state a cause of action for a will contest. Now, as Your Honor pointed out, we agree that Tennessee has a very broad pleading standard, very liberal. All the facts are admitted as true, but it doesn't have a non-existent pleading standard. There has to be some level of pleading to set forth some basic factual allegations to make a complaint. And we cited in our brief the Webb case, Tennessee Supreme Court case, and I think really the court in that case sort of had this particular case in mind. And I'll just read one sentence from that case. The court said, "To be sufficient and survive a motion to dismiss, a complaint must not be entirely devoid of factual allegations. Tennessee courts have long interpreted Tennessee Rule of Civil Procedure 8.01 to require a plaintiff to state the facts upon which a claim for relief is founded." And that's really what we're dealing with here. The most common allegations in a will contest are either that the decedent was incompetent or that there was a lack of undue influence. That's in basically every will contest. Those are always there, usually both of them. The amended complaint in this case alleges that by reason of her physical infirmities and mental illness, the decedent was of unsound mind. That's a conclusion. A stranger to the decedent could have alleged that. It says nothing more. So by reason of physical infirmities, well, what physical infirmities Had she had a heart attack and so was feeble? Was she bedridden? What were the physical infirmities that are alleged? There's nothing in the complaint that talks about that. As it relates to unsound mind, usually in every will contest, when there's an allegation of lack of competence due to unsound mind, lack of capacity, there's some allegations as to what that is. So did the decedent have dementia? Was there some type of cognitive decline? Was the decedent hallucinatory? What was it? Give us one specific factual allegation that says why there was some unsound mind. Obviously, they don't have to prove their case, and that's not our position. But you've got to allege some basic underlying factual allegations to prove your point. And the same is true for undue influence. Again, they asserted the conclusion. So they assert that there was undue influence by virtue of dominion and control. Well, that's stating the conclusion. So how was there dominion and control? Normally, to survive a motion to dismiss, you have to set forth usually some suspicious circumstances. So there may be some allegations that the defendant was prohibiting the decedent from seeing friends and family, or that the defendant had a power of attorney and was using that to their benefit, or something that says how they took dominion and control. They haven't alleged any facts in this case, not one fact, about how this dominion and control was exercised. They've stated the conclusion. So that what they've said is just simply not sufficient. And, Your Honors, this to me would be analogous to a situation where a negligence claim is stated, and the plaintiff sues the defendant for negligence. Okay, they've said you were negligent. Well, how? Did you run a red light and hit someone? Did you cause a slip and fall? How were you negligent? It's the same thing here. Or, for example, in a breach of contract case where it says, we had a contract and you breached it, and that's all that's said. Okay, well, what did the contract provide? Which particular provisions of the contract was breached? Something underlying in the factual allegations to say why your cause of action should be sustained. And it's clear in this case that that the plaintiff is hoping to discover some facts in discovery that will support their naked conclusions. That's what this is, a classic fishing expedition type of complaint. They don't have any facts. And I think it's telling that there was no request for leave to amend their amended complaint to raise any more facts. And the reason they didn't do that is because they don't have any facts. They are essentially strangers to the decedent in this case. And they just alleged just a bare bones, well, there was undue influence and she had lack of capacity. That's not sufficient under the Webb standard. It's not sufficient under Rule 8 to state a cause of action. So it's our position that the trial court reached a correct conclusion in this case. They don't have any underlying factual allegations, and we ask that the court affirm the trial court's decision. Thank you.
Thank you. Hear from the appellant, rebuttal.
The ultimate issue in a will contest is not whether there's undue influence. It's not whether or not there's lack of testamentary capacity. The ultimate issue is whether the will's valid. And there are grounds that you can allege to invalidate a will: fraud, improper execution, undue influence, or lack of testamentary capacity. Now, that's the ultimate issue, and that would be a conclusion. Allegations, the counsel had cited the Webb case and stated that, and correctly, that the complaint must not be devoid of factual statements. The amended complaint presented in this case has factual statements. It has factual statements to sustain a cause of action to set aside a will for undue influence and for lack of testamentary capacity. And counsel did a very good job of discussing the Tigg case, or of discussing a ruling in the Tigg case, that courts are supposed to give the plaintiff the benefit of all reasonable inferences. We may get to trial and fail on some of these allegations. That's just the reality of pleading. But for today, for issues regarding pleading, all reasonable inferences are to be given to the plaintiff. And for those reasons,
Counsel, I'm sorry, your timing. What, you said you did make factual allegations in the amended complaint. Like, give us some examples.
in the amended complaint, specifically it's paragraph 3. It's entitled Basis of Contest. The plaintiff alleges that the decedent was incompetent and or disabled at the time the 2018 will was signed, and by reasons of her physical infirmities and mental illnesses, the decedent was of unsound mind. 4 bases for sustaining a cause of action for being unsound mind or lack of testamentary capacity. It's the same thing under the estate of Kiesler estate. The plaintiff also alleges that in the decedent's 2018 will was a result of undue influence upon the decedent by the defendants by reasons of dominion and control, which was exercised by the defendant Temple Reese upon the decedent in an effort to persuade and influence the decedent to name Temple Reese as the primary beneficiary of what became the decedent's 2018 will during the decedent's lifetime. These are factual allegations. They are, right now, they're presumed to be true, and if true, all 8 of those can sustain a will contest in the state of Tennessee. We didn't seek to amend our complaint because there were adequate factual allegations to sustain a will contest, and we'd ask that the ruling of the trial court be reversed and this matter be remanded to the Circuit Court of Johnson County.
Thank you. We appreciate your arguments and your briefs in this matter. If you would, please adjourn court until our next regularly scheduled docket in May.